Hi, welcome to benchmarking. We are so excited to talk about what we've been talking amongst ourselves for the last year and a half to some amount of time. I think this started with you and Christine Park talking Rebecca and Christine Park talking about some benchmarking ideas, and then slowly we started adding others onto our little internal research group where we spent a lot of time discussing what is benchmarking, what can we do about it, how should we proceed. One of the things we wanted to do was give people a way to do benchmarking if you didn't have like APIs, or if you wanted to find, a way to benchmark different kinds of legal research, AI technologies in ways that work for you. But you can see we've been doing this for a while. We're still sort of struggling with some of the basics. What is benchmarking? What is hallucination? What is an error? And we have been, slowly writing things. So right now we have a Spectrum article coming out. And John, I'll ask you two to talk about that in a second. And we're also working on a blog post to talk about some of our direct experiences with attempt to do some benchmarking across different legal platforms and what we found. And hopefully we'll publish that sooner or later because we've been trying to for 7 months. I am Debbie Ginsberg. I am faculty services librarian at Harvard, not Chicago yet. And I've been interested in different kinds of technologies in a long time and how they affect legal research and the practice of law. We'll have you two introduce yourselves and add anything you want to what I just said, and then the two online.
Hi, I'm Rebecca Fordon. I am a law librarian and a professor of professional practice at Ohio State's Moritz College of Law. And I have been teaching legal tech for a while, teaching legal research, obviously, and thinking and writing about AI a lot in public over the last couple of years. And I feel like the more I learn about benchmarking, the more legal research AI specifically, the more I realize that it's really, really hard and it's going to take a long time. And that's, I think, been the lesson we've learned so far. And so we'll talk about why that is.
I'm Nick Hafen. I'm a librarian and the head of legal technology education at BYU Law School. Relatively new to law librarianship, just a couple of years before that. So I teach a lot of technology courses. I teach our AI course. I was welcomed with open arms into the benchmarking group a little while ago. It's been great to work on.
John?
I'm Jonathan Franklin, a digital innovation librarian at the University of Washington, and a relative latecomer to this group, but had some parallel research interests, and I've taught legal tech and I've really been focusing on AI for the past 2 years.
And I'm Sean Harrington, the Director of Technology Innovation at University of Oklahoma College of Law. And I was, I guess, kind of one of the middle ads to this group. And I'm very excited to be a part of this because it's just connected a lot of really smart people who are thinking really deeply about this stuff. And my little contribution is like Jonathan, I've been really focused on AI in the last few years.
All right, so we're just some general things we've been thinking about. Of course, the biggest thing is what does it mean to benchmark? And I think you're going to start us off with that one.
Yeah, so I'm guessing people here are probably familiar with the term benchmarking, but in case it's new, it's just having a common basis to compare tools, right? If I think of like cell phone reviews, they're always doing tests to see how the phones compare to each other. Like they'll test the battery. They do the same tests every time so that they can compare across devices. They'll, charge it up to 100% and then crank up the brightness and the volume all the way, and then turn on, because they're all millennials, probably like, yeah, by Usher, until the battery runs out, and then they have a basis for comparison. So this is a big area in large language models and these AI tools. We're going to talk about some of the challenges there in a bit, but you've probably heard about some of these, right? People have used the bars, that's the bars. People have done tests on law school exams. If we make it blind, how does the ChatGPT exam fare against the exams? Anybody want to add to that initial point? On what benchmarking is
We're also been talking about things, there's just other standard ways that people have done damage writing in the chat box in general. So, and you know, people have probably heard, how many R's in strawberry, right? And so often it'll be like, it counts 2 R's. So trying to convince it to count more is difficult. In other ways that, you know, we've done this, and also technical ways as well. I don't know if any of you two want to speak to some of the technical benchmarks that. See there, sorry, they're over back there, you, they're over here.
Yeah, I mean, it's one of those things where if we had access to this stuff, there's a whole host of tools that you could very easily use to benchmark, you know, how a retrieval augmented generation pipeline, how effectively it's pulling something out of it, or how, you know, all of these different ways that you can measure these things, but we almost never have backend access to any of these. And so, you know, that's a very limiting factor when attempting to benchmark any of this stuff, which is, you know, if we had API, if we had backend access, we could do it, but it's all proprietary. It's all their secret. I specifically asked Damian Reel. I said, hey, when are we going to get API access to VLEX? He said, that's our secret sauce. We're never giving you that. And I said, ugh. So it's put us in a difficult position, not an impossible position, but a difficult position, which Jonathan and I will talk a little bit more about later.
Nick, why don't we talk a little bit about the goals of what we're trying to do with some of the benchmarking stuff?
Yeah, like I said, it's to have a common basis for comparison, right? And I see this as there's a few kind of subsections to it, right? People want to know in law firms, in academia, you know, everywhere these tools are being used, are they good enough, right? Are they good enough to do what I want to do? Good enough to use in any capacity for legal research, for example. But people are also interested in seeing, right? Which ones are the best? I've learned at the law school that people, you know, I would always say, look at all these cool tools, and I'd show them everything that's available, and I would get feedback, like, just tell us what's best, just tell us what to use. And so that's something people are very interested in. Like, will it do the job? That's kind of the floor. And which one is best? And that's the ceiling. And then in between, we have all this, like, what are the limits? What types of questions does it work well for? What are the, you know, does it catch it if you give it a flawed premise? All those questions in between finding the goals of benchmarking.
So what's our job as librarians then?
Our job is figuring out how to do that, right? Our job is figuring out how to teach, what to teach students, and figuring out how to use the tools, how to, like I said, what are the suitable for and what are suitable for.
And when we do benchmark, what are some of the benefits we do get out of benchmarking? And this is for everybody.
I think one of the things that we found or that I found is it pushes you to be more rigorous in your thinking. You have to, you know, once you say, let's figure out which ones are hallucinating the most, all of a sudden you realize you have to figure out what a hallucination is. And you have to think about that and think about the different types of errors that a tool could make. Anybody want to comment on that?
So
It definitely encouraged me to think about, like, what do I expect this tool to do? And that's been like us kind of, and when I talk to other librarians and teaching, I think that's something that we're all struggling with. Like, what are we supposed to be using AI for in research? And I think a lot of people that I talk to anyway say nothing, like, I'm not using it, like, at least the experts that I talk to. And that kind of worries me because the students are using it, they're using it for something. And so I want to know, like, what is it good for? What can I tell them that it's good for?
And you did some work, like, you know, we say use it for legal research, like figuring out what that means, what that process looks like, what each has, right?
Yeah. There's this in like search information studies, there's a lot of focus on like typologies, on like what are different types of searches, different types of tasks. And so I've done some work trying to like break down what our typologies are in legal research, like what types of tasks do we do, what are how can you break that down into subtasks, and I think that is helping us as we are starting to develop question sets and to develop our rubric, like in other, we're gonna talk about some other studies. But like one of the big legal reasoning benchmarking studies, they looked at IRAC and they broke down tasks into one of those 4 kind of things. And in legal research, we have a different kind of like way method that we go about legal research. So trying to kind of fit our tasks into that.
One of the things I've been interested in is it's also helped us to really start focusing on how humans interact with these things. Because we have these expectations of AI, we have to sort of compare it to how humans actually handle these same things. We'll talk a little about that, some of the interesting observations that came from some studies. And what we're also hoping is like these information can help improve these platforms, right? So as we start to provide feedback, this is working, this is not working, we're hoping some of the platforms will take what we say, what other benchmarkers say into account and make improvements. But then of course the challenges, and I think Jonathan and Sean have a lot to say about that.
Do. Sure. I mean, I think that one of the challenges, and this is a town versus gown issue, is looking at the things that law students want to know, for example, how to do well on exams, especially when they're open book, and how we teach legal research, whether it's closed book or open book. And then in contrast, what lawyers ask AI and what questions they want answered. And so we're really looking at this huge multi-dimensional matrix of questions and answers and demands. And at the same time, I think that one of the issues for those, at least in academia and in law firms, is also what is our role as law librarians in the awareness of benchmarking, the awareness of tools, and the awareness that we're potential to be educators and experts. So there are a multifaceted approach to the issue. But underneath it all, I think is the question of, what is the standard? Where are we headed? And how do we teach towards some place that we're not at yet? Right? If you're teaching legal research to a 1L, they're not going to be in practice probably for a couple years. So you're always kind of looking, like when you're taught to drive, you don't look at the hood of your car, right? You're supposed to look farther away. And I think that one of the interesting things about this group and thinking about benchmarking more generally is that you're not staring at the hood. You're not focused on what is next month's contract or what can this widget do, but what will this widget be able to do in a couple of years? So I think it's that multi-layer thinking of short-term, mid-term, and long-term.
I think that's very well said. The other thing is, these things are stochastic. They're not deterministic. And when we teach legal research, we do our best through, really complicated Boolean expressions to ensure that the output of something like a Westlaw produces exactly the cases that we want. Well, it's almost impossible with these things. The other thing is the current development cycle is like 3 to 6 months. So all of you out there who are aware of ChatGPT 03, that didn't exist 5 months ago. So it's a completely different type of model. It's a reasoning model. It was something that existed, but it was not widely available. And now, they're going to be starting to plug those things in on the back end. And then I talked about the kind of black box nature, which is like the Susan Neville article on steroids now, because that was just talking about an algorithm. Frequently what they're doing is they're leveraging, several different models that they host in-house to save money, calling the OpenAI API, calling the Claude API, doing a little BERT model locally so that they can sort stuff. So it's just so much is going on with this that it makes it such a constantly moving and kind of slippery terrain where, kind of once you think you have good output or you think you have a way to reproduce output, the next day everything has changed and you can't do it. So it's really, really challenging. At the same time, really exciting because they do things that are just amaze me every single week, but attempting to think through how to get some sort of rigorous evaluation on them is really difficult. And then Rebecca's done a lot of work. She put together this fantastic board at one point where, if you ask these things, hey, find me the statute for felony murder in California, well, they'll pretty reliably do that, right? But that's just a little tiny thing that, maybe you do just occasionally. If you're doing a big question, like what's the standard for copyright of AI materials in light of the recent blah, 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 well, then they're all going to have different output. And some might be better than others and maybe worse on a different day. So it's a really, really tricky thing to do. And, that's why I was really excited to be a part of this group, is to have people who are well versed in this type of thing for decades now, providing kind of input and thinking through these things in ways that just wouldn't occur to me.
Yeah, Sean, you talked about the back end, what's going on behind the scenes. What would we gain? What kind of information would we get from access to that, from knowing more about that? How would that add to our benchmarking abilities and what we can figure out?
There's a ton of tools out there. So there's a whole cottage industry, and there's no kind of industry standard leader in this, but there's all kinds of tools that you can use to measure LLMs, measure something like a RAG pipeline, measure, inference. I mean, you can measure kind of everything on these things, but because we don't have that, we can't leverage any of those. A lot of those tools are open source, they're free, so we could just do them. And so, when I think through like what's something that we could kind of collectively do is lean on these vendors and say, if you're not going to give us these back end, at least use some of these industry standard tools and produce white papers based on that. And that's not really what they've done. They've measured them against humans, they've measured them on certain tasks, but I haven't seen any one of them that said, okay, we used Arise, which is, an API tool that measures X, Y, and Z, and we're going to produce a report every, 3 to 6 months on this thing. And then, another thing I think about frequently is these tools are going to be good at some parts of the law better than others, and each model is going to be different. And so that would be really useful to know, how effective is it at civil litigation versus, arguing in front of the Supreme Court versus, family law, bankruptcy, whatever. So some sort of like, subject specific, topic specific, evals that we can start running on them. Like when you look at, you can go to SWE eval benchmarks, which are one of the coding benchmarks that they use for like the AI tools. Well, we don't have anything like that for legal tools. And so if we started to develop these kind of benchmarks, again, even if they didn't give us the ability to run them, but ran them themselves, that would be kind of a step in the right direction.
Thank you. One of the other challenges we've had is, with some of these non-legal benchmarks, there's an answer. If it's math, often there's an answer that you can get to, but with legal, we don't have a huge body of like agreed upon questions and answers to benchmark on. Because the answers can vary quite a bit. People can disagree on what the correct answer is, but also because a lot of that data is in law firms, places that I'm really sure. Anybody else want to mention any other challenges?
One thing we did write down that I'm thinking of now is, of course, the information that we're basing this on, good data leads usually to good outcomes. The data that's inherent within any legal research system has problems and issues with it, right? So, we're sort of like figuring out this is the best legal answer, but what is a best legal answer in a world where, we can have issues with, how the cases were written, when the cases were written, who got to write the cases, who got to write the statutes, what that particular focus is, and so that can lead to issues as well. And it's not math, it doesn't have an answer. It has an answer within a context, within a larger context, within a larger context, and this leads to some challenges as we go forward.
So Rebecca, what have people already done?
So there's a few that you might have heard about. There was a pretty prominent last year out of Stanford where they benchmarked legal research AI, and immediately librarians pounced on it because they were benchmarking, looking for hallucinations in legal research AIs, and for Westlaw, they looked at practical law and they asked questions that practical law would have no way of answering, and so librarians went nuts over that. We hated it. But overall, like it was a really interesting study. Like they did a lot of work to try to identify what they meant by hallucination and look for different types of hallucinations that came up in the questions that they asked. And they had a few different task sets, some of which were designed to kind of like trick the AI. So tell me about Justice Ginsberg dissent in, I forget what, like Obergefell or something. She didn't dissent, right? But that's a type of hallucination that LLMs are susceptible to kind of agree with whatever you say and just kind of go with it. So they had a few of those kind of tasks where they're trying to trick you, trick the LLM, a few kind of tasks that were just like pretty straightforward, like match this case with its holding, something like that. And they found pretty high rates of so-called hallucinations across all of the platforms, which was not the result that I think any of those legal research vendors were looking for. Anything else that I know you have more to say.
Not on that one, because I think they've accomplished that, like, you know, the fact that, like, it was really the hallucinations and the fact that they were defining hallucinations in specific ways that sort of like seem to go with their own conclusions versus, like, you know, making something up versus getting something wrong versus some other kind of error, because there's different kinds of errors that can be made. But we'll talk about that in sort of like what I didn't like about it in general, because they weren't the only ones to sort of go do that.
Yeah.
What about that Michigan one? I love that Michigan one.
Yes, so this one was just from this
Or
year.
Michigan and Minnesota.
Yes, University of Michigan, University of Minnesota, lead author is Daniel Schwartz. And by the way, if you go to, some of us have a blog, a few of our, Sean and I, along with a few other people, have a blog, AILawlibrarians.com. So I just went ahead and made /benchmarking. So I threw these studies up there. So if you want to take a look at these studies, feel free to go there. So yeah, this one is pretty recent, just from a few months ago. And what I really loved about it is that they didn't just measure, like, take the output from an AI prompt. So the previous studies that have been done on legal research benchmarking and legal reasoning benchmarking, it's just here's input, here's output, and you look at the output and see how it meets a rubric. Well, that's not really how people use any legal research product. Like, you wouldn't download the top 20 results from Lexis and just turn it in to your assigning partner, right?
Never mind.
You should. So what they did is they did a random controlled trial. So they took law students and asked them to complete one of, I think, 6 different tasks and to use one of 3 different services. So I think they did ChatGPT, the new reasoning model, it was new then, as well as Vincent, and there was a third one that I am not remembering. But they looked at 3 and they had the students complete those tasks. These weren't just legal research tasks. Most of them had some legal research component, but they also had like a drafting component and like a reasoning component. So like one of them was like draft a document that has this specific kind of clause that complies with this law. And they had to have caught that there's like a law that says you can't have that kind of clause that has to have these components, right? So they had to have caught those kind of things. So they did that, and then they measured on a couple of grounds. Like they measured, and the authors of the study.
But there's one more thing. They also had them do the same exercises without AI.
Yes.
So they could do, so they could,
Yes,
it was not
that's
just AI, there was also a non-AI component, and within the group, each cohort got to like try all the different systems. So
Yes.
they didn't, you know, a non-AI, an AI, and another AI or something, so.
And they also had a law librarian involved, which I
Very
like,
important.
who trained all.
Stanford did not, by the way.
Yes, who trained all of the law students on these various platforms, which I think was really, really helpful, and taught them like basic legal research in case they didn't happen to catch any of that in their law school classes so far. And so they did that, and then the authors, who are all, I think, all law professors, graded it, and they graded the problem they designed. And they graded it for accuracy, like did it get the law correctly, clarity, there were a bunch of others. What else did they grade?
It's in the study.
Yeah, those were the 2 ones that I paid a lot of attention. Oh, time was another
time was a
really
big one.
big one.
Yeah, there was a kind of efficiency component.
Yeah. And what I was really struck on, because I zeroed in right on the legal research, of course, is that the legal research tasks were not improved in accuracy with the AI.
It went down.
Yeah, it went down on some tasks, in fact. The time was shorter. They also asked the students, like, how do you feel this helped you? And they thought it was awesome. Like, even on the tasks that decreased their accuracy on, they were convinced it was really, really helpful. So I would recommend if you're at all interested in how people are using AI, go look at that study. It's my favorite one of the ones that I'm hearing about.
Then there's the ones the librarians did, Cindy and Holly.
Yes.
The legal.
Do you want
No,
to-
I'm having, because I want to
Okay.
get the other, because
Okay.
I'm not detail person, I want to talk about these other things.
Okay, so you may have heard this too. This is at SCAL, which is the Southern California chapter of AAAL. And I think there were 3 of them, law librarians, looked at a few different questions on a few different platforms and just talked about that at SCAL, which I think is just wonderful. I think we need to do more of that. And so that's kind of what we're trying to do with this blog post we're working now, and hope to continue to do. But they ran them through the different platforms and just talked about the results. And then Bob Ambrosi wrote it up. So if you want to know what they talked about, you can actually go to, I have linked the page, you can go read about everything they found. But kind of one of the things that I found interesting about that is that some of them found like the smoking gun better than the others. So I thought that was one interesting approach to benchmarking, is if there is like a few key things that they really are supposed to find, like that's an easy thing to check, and like a machine could even check that. Like if there's a leading case, you could just see if someone found it. That's like a simple yes or no. So that's one of the things I took out of that.
And I'm using that in my part of the blog post that's coming up, the smoking gun.
Yeah, I was gonna bring up my part of the post, even though it doesn't make me look great, because I did the model answer in response to this bankruptcy question that we came up with, a particular provision. It asks how does the Second Circuit treat this provision? The Second Circuit hasn't, the Circuit Court hasn't ruled on that yet, but it has ruled on an almost identical provision. The language is almost the same. One of them has to do with rent, one of them has to do with personal property. And so whether a platform gets that second, the similar, like that's really useful for a lawyer. This isn't exactly that it's in the same section and it's almost identical language. So if the Second Court has ruled on that, it has in February of this year. That would be really helpful to know. I didn't put that in my model, so and only Vincent of all the platforms that I tested picked up on that one. So that's another example, like how it can be hard to define. Did they give me correct answers on the provision I asked about? Generally, yes, but to the point of like this random controlled trial, we want to know, is it useful, right? And this one was more useful because it went beyond the specific bounds question.
So, in looking at all these different exercises, there are things we're looking for, like, I'm excited that the snack down includes Fordon librarians, because we want them part of the conversation too when we're talking about these benchmarking, because they're the ones who have to work with this, introduce, do the training for the lawyers. We're here in academia, but we want the lawyers to, see what they're doing and see how they're being trained as well. So I was excited to see that. And there are things that we think really works, and we keep talking about specific tasks. And so the fact that all these were based on specific tasks, it becomes reproducible. You can go home and try this on yourself on whatever platform you have access to see what you get. They also tested a range of tools, and some of which we don't have access to. So some of us have access to Vincent. I don't. And I would, it's fun to see how things I don't have access to or others don't have access to respond.
And none of us have Harvey because we're all academics.
What? And none of us have Harvey.
Yeah.
Or a bunch of other of these things.
Yeah.
Again, great chance for us to work with our law firm friends to get a better idea how some of this stuff works. I love the fact that we get these great detailed analyses out of all of these. The Michigan one is still one of my favorites because it's got all these tables and it shows different percentages. It really did a good job of taking what can be fairly abstract and making it more concrete numerically. And I thought it was okay. I'm going to add to that. So I didn't already say that because I've had a whole thing about measuring attorneys with tasks rather than just measuring AI output. But one of the things I thought was a Michigan study is they asked about hallucinations, not only for the AI part, but for the non-AI part. And they found hallucinations there as well. I'm not sure what they meant by hallucinations, if it's just errors, if somehow people made up entire new cases, which is entirely possible. I know there's some people, I think Sean, you've mentioned this at one point, that are working on figuring out what is a hallucination before AI. Like, it's not like this entirely concept. You know, what does that mean for AI to hallucinate versus a human? And of course, the fact that this was all graded by experts, so you pointed out that, you know, the faculty themselves did the grading on the Minnesota-Michigan study. That sort of, you know, makes it so we can sort of trust those outputs. Did you want to talk about the hallucination? Am I correct in remembering that you the one who brought that up?
Jonathan, he's talked about
Yep.
it a lot about it deeply.
Well, so Andrew Martineau at Minnesota was the one who did the training and also did some of the analysis. And so part of what the question was in that context is, what is a hallucination more broadly? And the authors of the article had to determine when a student or an AI did something. Was that a checkbox in the hallucination column, or was that you know, a just regular old error or misinterpretation or something else? And you know, we're all used to the Likert scale of a 1 to 10 or 1 to 5 or something like that. And really, this is a far more nuanced area than the binary construct of hallucination, not hallucination. So if I cite a case, and you guys are in Georgia, and I cite a Florida case, is that hallucination? Because really there might be some precedent in Georgia, and this is just persuasive? You know, and so I think there's a lot of nuance to how you do these studies that will skew your results. And thinking about the subtlety, you know, one hand might be a case that doesn't exist, right? But then what happens if it's a typo? What happens if I wrote it was on page 911, but really it was on page 991? Is that a hallucination? You know, I think reasonable people could differ. If I run my computer program and there's no case starting on page 99911, then it's going to say that's a hallucination. You know, but if a judge is reading, you know, the brief, and 16 times it refers to the correct case on the correct page, and 1 time it refers to the wrong page, nobody's going to sanction that attorney, right? And so I think one of the challenges as we look at this thing is how we can't be mechanistic. I really came into it hoping we could be. I was just ready to scarf up loads of data and sort it all and come out with some awesome answers. But that's really just not the way it works. And the granularity that we've gotten to is at a point where I think we've learned a lot and we can move forward better, but it also means we're not going to have quick answers. And any study that we put out is going to easily be critiqued by whichever vendor or whatever didn't do that well. So I'm pretty prepared for there will not be a non-controversial legal research benchmarking study.
Right. The second, the problem, the things that we didn't like, which is how hallucinations were defined. That was my problem with the Stanford study, where sort of like everything became a hallucination. But the problem is, of course, then it gets out into the real world, in which, you know, where hallucination is something, you know, it's made up out of whole psychology. I actually wish this was called confabulation, but that's a whole other set of.
That's all just false output, like just be clear in your language what you were talking about.
Right, so by calling it hallucinations, all these things like, you know, oh my God, Lexis hallucinates 87,000 times, and it sounds like Lexis is making up 87,000 cases, which is not happening. Lexis is making other errors, but they're not making those errors that we traditionally define as hallucination. So it sort of like becomes misleading and it's not clear as to what's going on, and it doesn't give us actionable information if we're not acting on the right concepts. The fact that, you know, Stanford didn't include law librarians was patently obvious and led to some really bizarre answers. Sometimes people don't understand the tools. So, you know, a not real benchmarking thing, but there's a recent blog post from someone who I know is really good at technology, and they wanted to compare Lexis to ChatGPT, and they, like, you know, did a natural language
The prompt, like the
Yeah,
whole
the prompt,
question.
well, the whole natural language prompt, but then Lexis gets 96 results. And that's how that's supposed to work. And then you're supposed to filter those results and ask questions about it. But they were really mad about that. And so there was all these results that, you know, were kind of meaningless without doing extra work. And so then they did the same thing in ChatGPT, in a version which, as far as I know, actually collects and transmits your questions back to the training data, which is another problem. And it's like, oh, I like that result. But you have to, you know, in both cases, we're not using the tools in ways that, as a librarian, I would be like to, I would teach my students to use them correctly. And so that can affect the benchmarking as well. Obviously they can only test limited tools and things are changing. Sometimes, you know, begin with things like the hallucinations, it's not always clear what they're testing on. Again, I thought Michigan and Minnesota did great. And I love the fact that, like, we saw one set of results. We've seen a pretty good set of results with students. I don't think we've really seen a good one with attorneys yet.
Not yet. That's what Valves is trying to do. If anyone's heard of them, that you might have seen, they came out with a benchmark of a bunch of different tasks in legal research. They were planning to release legal research at the same time, and pretty quickly figured out that it was really hard. Like, we are figuring it out, and so they say it's coming, but they are getting attorneys there, I think, or trying to.
Right. Well, we can get out of all these studies or things that people are benchmarking and that can, you know, we can use it going forward. Things like, how does the UI work? Defining what hallucinations are. Sometimes people are really into speed. So we know if you're using some of those reasoning models in ChatGPT or others, or even in Lexis and Westlaw, you put in the question and you might wait for a little bit for an answer. So people might be looking for that. They might be looking at, you know, the format of what is output. So some of the things will just give you a sentence or two, some will give you a full memo. And that gives us a thing to compare it as well. So that's some places for us to start with benchmarking, but I think we're going to want to go further than that. Does anyone want to add on any of the things we've just been talking about the last?
Yeah, on the hallucinations, you know, for like true, absolutely confabulated cases, that is something that could be solved pretty easily. All it would take would be to do something that Mike Listener from Court Listener has been championing forever, which is make the citations available. You know, Jonathan was able to put together a prototype of a Word plugin that would you could give it to every court in the United States, and if you ran something through it, it would just flag the cases that were completely made up through the Lexis API. But we don't have the ability to do something like that. So to the extent that we can, you know, get them to open source just the citations, that would be very, very valuable just to the entire legal US legal ecosystem, because you could wave away anything that had a completely confabulated case. Now, it wouldn't touch all of the edge cases that Jonathan talked about, where, you know, you have to do something deeper, where you look at, you know, is it close to this citation? Is it citing the language correctly? You know, things like that. So it would get much more complicated. But just to wave away all the ones that are completely made up, technically we could do that right now if we had access to the citations.
I just want to say, on the point of open citation networks, we are a couple of us from Free Law Project are talking tomorrow about that. So please.
Awesome.
Debbie, what you mentioned about that lawyer that didn't use the tools the right way, I think brings up an important point. Like, is the standard for comparison what an attorney would do? Because sometimes, as you said, that's not, you know, at the level it should be. So what is the gold standard?
Right. Well, actually, that's the question that I had for the two of you. It's like, what's the future? What's the gold standard? Because as a librarian, I want everyone to, like, you know, research the way I taught you. And the fact that I've like gone up to a bunch of 2Ls and go, all right, you know, what's a secondary source? And they all, and also 1Ls that I just taught them the week before, and they'll look at me blankly. Secondary what?
You know, like you said, like the way that we teach it and the way that people actually do it are so different. And I always think I bring it up all the time. But Cassie Walker from SMU, she did her final as a live assessment where she would, you know, give the students a task and she would watch them via Zoom as they did the task. And she told the people at her presentation, I had just taught them, you know, treatises, secondary practice materials the week before. I give them the task. The first thing like half of them did was like go to Google and find an attorney blog. So, you know, there is a certain amount of us as law librarians, you know, we have a methodology that we stick to that we know is going to be effective. Are real attorneys out in the wild going to do that? Are law students going to do that? I don't know. Are they just going to use whatever's expedient? Do these tools 95% of the time give them mostly what they need? And so they kind of wave us away like, I'm not going to spend a half hour if it takes 2 minutes. I don't know. That's something for us to, I guess, struggle with internally as law librarians. But I think we've had a few steps in the right direction in recent years, or sorry, recent months. So if you've used a service like Perplexity, it's really cool because you'll say, hey, go to the web and find me a baby seat for my kid that fits this under $100, is safe and whatever. And it'll say, here are the keywords that I used. Here are all the sites that I went to, kind of it gives you a little audit trail of all the things that it did. Well, with the reasoning models, we're kind of seeing that in the law, legal ones a little bit more, where they're saying like, I'm thinking about the thing in this way. And so you as the user can kind of audit what the thing is doing to kind of redirect it. So that's a step in the right direction. It would be even better if we could see where it went to, what data, what databases it went into, what cases, what statute, what keywords it's using. That would be enormously useful. And it's something that would be trivially easy for them to implement on their end. So that's, kind of another thing where we can give them feedback to say, man, this would be really helpful if you could do this, because then I could skim it and I could spot all the places where you didn't go. And then, I'll pass it over to Jonathan because I could talk and talk.
Yeah, we could both talk about this for 50 minutes.
Yeah, for session.
I mean, I think that one of the aspects of the future that is cost, and I mean, I think a lot of this ties into some of the things that Sam talked about in the keynote, which is people are driven by cost and convenience, and we can't ignore that. So I think that basically OpenAI, Claude, all these companies, all these general companies are going to be providing more and more legal advice as people have questions. And I don't think that's the unauthorized practice of law, because I don't think any bar wants to go tell OpenAI that it's violating UPL. So there's some really interesting political aspects to this. But I also think that when we're benchmarking, are we benchmarking these systems to the quality of a lawyer? Are we benchmarking these systems to the quality of a law librarian? And also, I think that law is smushy. I mean, or some people would say that 90% of the cases that go to appellate court are fairly clear-cut and you get a 3-0 decision. And then a lot of the rest are, the remainder are 2-1 or edge cases and things like that. And so really, is 90% good enough? I think we have to look at what expectations are and not say that anything under 100% is fallible and bad. Because I don't think that's the way people operate right now. There's this word that's been around forever called satisficing. And, it's just like, yeah, that's good enough. Okay, cool.
On that note, I mean, I think that there's a real possibility in this market. Not every attorney needs the entire database of cases that's in something like a Lexis or a Westlaw. And for many of them, open data will be good enough if you're practicing state law in your state civilly. So that opens up a position where, either one of two things happen. Little tiny state law tools pop up, which is, this little narrow data set for practice areas. The other thing, which is I think probably more likely, is that my Zoom camera. OpenAI is going to go scoop up. Scoop up. I gesture wildly and have one of these zooming cameras. It's going to go scoop up. And I've heard already that it's, trying to talk to Court Listener. It's trying to talk to Open Laws US to get, enough data to be useful to a huge chunk of attorneys. And so that's going to be potentially very, very interesting when ChatGPT has enough back-end data to do a lot of work for a lot of people. And, I don't know what that will mean to the future of how we teach it, law, whatever. If it just kind of consolidates it all into these like big, massive platforms.
Right, but that also means there's going to be a lot missing. There's a bunch of stuff that ChatGPT and never have access to.
Well,
there are paper records, and again, as law librarians, we know you also need to skip those. And that again leads to bias and different issues within the systems and things not changing if they need to. And so again, there's always going to be, and the things we should be thinking about benchmarking is what's the effect going to be on the system as a whole.
think that ties into what we were talking about also before, which is this limitation. Law schools have had not free, but lower cost Lexis and Westlaw for decades. And we are now at the point, as Sean and others mentioned, where we don't necessarily have access and cannot afford access to Harvey, Paxton, whatever. So we're thrilled to be able to try these various tools, even without an API, just to see what they do. But the vast majority of people will not be able to gain access to the content in them. In the same way that we don't know, I mean, in my site checker, I have no idea how to site check WL citations. Because, I mean, unless they're out there somewhere already, which is wonderful, I don't know what a WL is a parallel site to that has a different pagination, et cetera, et cetera. So even if the case exists or not, it's this Schrodinger's box, as long as it's locked up. And that inequality of access to data is relevant because if we're benchmarking for big law, it's huge, right? They have access to a far more than small law. So a benchmark for one law firm might be more relevant to that firm than to a different firm of a different size or nature.
So as like our benchmarking group, if, what would be what do we think would be useful benchmarking systems or questions if we could do that?
Oh, so many. So, I mean, I think that a lot of the knowledge in law, and this has been done behind closed doors, so I'm not saying anything radically new, is these knowledge graphs and the ability to understand the law at a more interconnected level. They've been done on some level with citation studies, but AI opens up whole new avenues for exploring the law and making it accessible to people. For example, you're limited with a key number system. You can only attach a certain number of key numbers to each thing. Well, that's actually an artificial limit based on Operant Digest. And you can add more and more and more. You could look at all the cases of a certain type by a certain judge, and there are tools that do this, right? Already, but we don't necessarily have access to them. Another area is dockets. I mean, Trellis and a bunch of other companies have dockets, and dockets have an unbelievable amount of information. So if we wanted to actually do a study of human hallucination, we could take pre-2022 dockets and run 100,000 briefs through and see what we get. So I think that's another future avenue of exploration, is to understand the practice of law over the last 100 years through the documents that people have suddenly been able to make available to some, and also that we now have the tools to study at scale.
I mean, I think about working when I was doing research for faculty, I would get these professors that would have like some access to justice question, and they would go, how many people of X demographic in this place have been X, Y, or Z? And you just go, we don't really have the ability to do that in any kind of meaningful way. But you knew that if they had that, it's a very powerful tool for advocacy for a number of different causes. Well, now we do. So there's a lot of empiricism that can be brought to bear on these tools that I think would be very powerful for how do we do legislation? How do we advocate for certain things? Are the things we're doing useful? Are they making any kind of meaningful difference? I mean, it could be a very, very powerful tool. And it was something that you just literally could not do previously. It was just the volume of information was just too much. You didn't have the access to it. It was just, yeah. So you could get a lot done.
All right. So we've been discussing some of our ideas. Again, we can go on all day, but we also wanted to know what all of you are thinking, and if you have any questions for us or ideas you want to share that we can incorporate into our little group. Oh, just one.
Oh yeah, we do have a Discord.
Yeah.
I could put it in the chat, but I don't think I can.
We'll add it to.
I'll put it on
Yeah.
our page, actually.
I wanted to respond to one of the questions that's in the queue, and this is about SNEOS.
Okay. Can you read it out because we can't see the queue?
Yeah. Oh, sure. Sorry, I didn't realize that. Yeah. Have any of you experimented with SNEOS? It's not exactly benchmarking, but rather output comparisons. 3 LLMs process identical prompts simultaneously, and it summarizes the differences. Now,
I've
this
used
is great. Go ahead.
I've used what's it called, Open Router, a lot, which is kind of a similar thing.
Yeah, it'd be great if there was a SNEOS for
Yeah.
Bloomberg, etc.
Yeah, I think that one of the issues right now is that people think they have competitive advantages with their secret sauce, and I'm just not sure that the emperor's wearing clothes there. I look I look forward to testing it, and that's part of the reason for caring about benchmarking is because I think everyone feels that things are proprietary right now, but everything is so easily replicable that if you
Well, and
have
like
the
the
money
purchasing
and
decision, it's not like you're in a firm and you're like, wow, Westlaw is doing this one task way better than Lexis. All right, entire firm, we're switching. Like it's just not how you make purchasing decisions.
yeah, and I think just interface. We're humans using these tools, and so I know where the button is on this thing, and I don't want to change to the one with the orange bar that has the button in the other place where I don't know how to do it. So I think,
Uh,
but I think that going back, I wanted to touch on.
sorry, Jonathan, I think we're trying to get some questions in the room.
What's SNEOS? What does it stand for?
It doesn't say what it stands for. It is a multi-chat AI assistant. I'm looking at it right now. Basically, you enter in a question and it tells you what the answer is on ChatGPT, Claude, Gemini, etc. Like all at once. I hadn't heard of it before. So yeah, it'd be wonderful if there was like something like that.
How do you spell
it?
Yeah, I was gonna say, can you spell it?
SNEOS.
So SNEOS is like, I'm looking at it right now. There's a different platform so that SNEOS is a tool that does a thing. The standard for that type of thing is a service called Open Router, where you can take, not 3, but you can take all the models. You could run 50 across all the models, and you can do it through the API too, and then measure it. So SNEOS, I'm sure it's a great service, but the standard for people doing AI stuff is called Open Router.
Other questions, thoughts about benchmarking? More thought than a question. So as we're all learning AI and we're learning how to write our prompts and how to make them better and then how to teach them, it seems like benchmarking is big picture, but when we're measuring things like hallucinations, some of them are because people are writing bad prompts. And so I'm quite sure how this evolution is measurable because as we grow, it grows. Does that make sense? So so you got 2 of our problems here. One of which we addressed, which is like different ways that people use the systems, right? Some of which were like, well, that's not best practices. And we were talking about, are we measuring best practices or are we measuring other things? Of course, the other thing is the systems are changing all the time. And we've talked about this a lot, like, while we've been sitting here trying to write this blog post in our hopefully spare time, we did one thing, then the system changed. We had one thing and the system changed. One thing, the system changed. Okay, we just got to get this out there before the system changes again. So yeah, it's a good thought and that's part of what we're chasing, which is part of what we're hoping to do is also come up with ways for like other people to think about benchmarking for their own selves.
Yeah, and I think it's really unsettling too. I mean, you used to be able, like, if you're a law faculty, if you're working in a firm, you could once a year dip into a Westlaw or Lexis training and you could learn kind of all the new features and kind of move on. This is happening every 3 to 6 months. And it's a completely different way to do things. And frequently, everything changes. A reasoning model will make it so that it understands a lot more and you have to prompt in not a completely different way, but a slightly different way. And so I think it's just a burden on the individual user to stay abreast of these changes is a lot higher than it used to be. And so, I'm not seeing these institutions, whether academic or firm or whatever, building in the requisite time to train people up on this stuff. And you can have all the fancy tools in the world like Harvey, but I've heard over and over again from people who work at, firms that have Harvey, like, nobody kind of knows how to use it. It's getting kind of low usage. Some people are like, oh yeah, we use a lot, but you have to build in that training time. And I haven't seen a lot of institutions, putting the resources and time towards that.
Jonathan has raised his hand.
You could just interrupt me. You don't have to raise your hand.
No, I think I just wanted to make sure that anyone in the room who has any questions on these topics, because I think that because the systems change and even the results change it's going to be harder and harder to benchmark because these systems are going to have context windows where they know that you work for an insurance defense firm. And because of that, it's going to skew the results. And it's going to help you. It's going to help write a better brief. But it means that benchmarking will be more challenging. But let's go to the questions in the room.
Okay. More questions.
Yeah, I'd like to talk about time. So that's the benchmark that is, that's it. That's why students are adopting this technology, even though it's worse. And it's why the attorneys are going to adopt it, because the bill law time is money, and that's our problem. So it's also the problem that like we don't have the time to teach it. Who should teach it? We don't have the time to ask that question. We don't have the time to actually learn it before we can teach it. So time is the major thing here, and how can we press pause? We need to resist the idea that rushing is beneficial to any of us. Rushing, as I learned in a Tatri's class, is white supremacy. So time, I think, is the most important benchmark that like is the reason why anybody is doing any of this. Is we don't have time to do the things that we really should be doing.
Yeah,
Yeah, I mean, so I'll speak to that. I think, you know, to some degree, I can be kind of techno-deterministic about this. Like, yes, I would love to press the pause button and thoroughly evaluate all this stuff. I just don't think anybody's gonna wait for us. And, you know, the biggest sign of that was us not getting access to something like Harvey. Previously, the legal tech vendors, especially the big ones, went, hey, it's really useful for us to give students access to Lexis and Westlaw, train them up on it, teach them the latest and greatest tools, because then they run to firms and they affect purchasing. You know, we've seen many of our students, they'll get tapped on the shoulder to say, hey, what did you learn about AI from your AI in the Practice of Law class? Harvey just said, you're irrelevant. We don't care. And so I guess that's the thing I worry about when I hear, you know, like, hey, we got to slow down. Hey, we got to take our time. Yes, I agree. But I don't think they're going to let us. I think that will only contribute to us becoming irrelevant, unfortunately.
yeah, they say
Yeah.
I wish we did, but that's the big question. How do we make the vendors do all the things we want the vendors to do?
one thing I think.
Why do we purchase it? Why do we
Well, that's a bigger
know,
question.
like?
One thing I think can help is that we don't necessarily have to all be experts, and like everyone shouldn't have to be doing their own benchmarking. And so what I really like to see is like just people trying stuff and talking about what they got. Like I hear a lot of that anecdotally, like, oh, I tried with this answer and I got a terrible result. Or I tried it on ChatGPT and it gave me better, or things like that. And if people kind of talk about it more, so it's part of what we're trying. Yeah.
One thought and one question. So I think law librarians are really doing great job guiding students on how to use these tools and really how to define success, right, when using the tools. At the end of the day, I think these are tools, and you wouldn't use, you know, like a chainsaw the same way as you use a hammer. Like ChatGPT is really designed and trained as the general purpose tool, like Leatherman. You wouldn't use a Leatherman to build a house. And comparing like ChatGPT and LexisNexis, it wouldn't be an apple to apple comparison, I think. And then one question is, I know we talked a lot about hallucination, but what I think is all the models hallucinate. There isn't a single model out there that doesn't hallucinate. Perhaps it's more about the severity of hallucination. Like the Vincent example that we gave, that you know, perhaps to a human is very useful, but maybe to some benchmarking, it's really hallucinating because it's giving you information that you didn't have.
Yeah, I think right tool for the right job is super powerful, and that's something we as law librarians can teach our students too, and attorneys. That's a place where I think we're really valuable. Is they frequently don't have the time to evaluate this stuff or learn what the best tool is or learn about the update or whatever. It's a really valuable service that we can give to them, and to make ourselves be like really, really important at these institutions. Ask for more resources, ask for more people, ask for more staff in our institutions, because I've been bullish on the fact that this is the time that we need to start expanding. And a great way to do that is to lean into this stuff.
As we start thinking about what's the future of law librarians is, with competing things of like, you know, a bunch of stuff is changing, but at the same time, we're sort of like, you know, caught between some of these expectations of our vendors. This is a good time for us to think about our place and what we're doing going forward. However, it is 11:30. And that means we are done here. Thank you all for coming. We'll stay up here for anyone who keeps wanting to chat with us. Jonathan and Sean, thank you so much for participating from all the way out to where you are. And we'll
We
see-
almost got hit by a tornado, and I still made it. Thanks, guys.
I'm glad you weren't blown away.